Good morning, everyone. My name is Mark, and on behalf of the Maine State Chamber of Commerce, it's my pleasure to welcome you to this Human Resources Update webinar. I'd like to begin this morning by thanking our sponsors. Our premier sponsor today is Verrill. Our webinar series sponsors are AARP, Central Maine Power, Delta Dental, Eaton Peabody, First Light, Kennebec Savings Bank, and Sun Life. Our supporting sponsor is Procter & Gamble. I have just a few administrative notes about this seminar. This seminar is being recorded for future use and will be made available on our website and our YouTube channel. You've all joined Zoom in mute mode to reduce background noise. And if you have any questions throughout the webinar, please type them in the chat function. And if you become disconnected, please use the same link to reconnect. In the worst case scenario, please reboot your machine. It is now my pleasure to introduce Peter Gore. Peter serves as Government Relations Specialist for Maine Street Solutions. Prior to joining Maine Street, Peter spent 28 years here at the Maine State Chamber of Commerce, initially as a Senior Governmental Affairs Specialist, and then in 2008, he was named Executive Vice President for Advocacy and Government Relations. Peter, welcome. Thank you.
Thank you, Mark, and good morning, everyone. Welcome. We have about 90 minutes for our program this morning. We may use all of that, we may not. Tawny and I have a significant amount of material to go through with you as an update. But before I begin, I want to introduce my co-presenter, Tawny Alvarez. She is a partner in the firm of Verrill Law and part of the labor and employment practice there. I have known Tawny for many years, and I'm very pleased to have her with me this morning. She is an expert on all things labor law oriented in the workplace and has represented employers in a variety of different perspectives over the years. And so her knowledge base is extensive, and we're really glad to have her as part of this. So with that, let me begin by giving you all somewhat of a thumbnail sketch of where we find ourselves. This is a legislative update. We are going to focus on what's been going on in at least the Labor and Housing and Judiciary committees this morning. And the first part of our presentation will be on bills that are active, either in the committee or in the legislative process. The second half of our presentation, we will go through the recently released LR9, the sponsor amendment to the Paid Family Medical Leave Bill, which is expected to be taken up in the legislature in the Labor and Housing Committee in public hearing on May the 25th, next Thursday. Currently, the Labor Committee has worked through about 53% of the bills that it was assigned. They have had a very busy legislative session, much like the legislature as a whole. Having said that, they were supposed to, as of this Friday, have completed 100% of their bills. That's not going to happen. The legislature has currently referenced 1,950 bills, which is not exactly, it's pretty close to a record. I'm not sure it's there yet. There were originally 2,200 titles submitted for this session. That was a record. And as a consequence, the revisor's office, that's the office that prints and works with the Office of Legislative and Public Affairs, Legal and Policy Analysis, excuse me, to make sure whatever bill is written is done correctly and in legal form and not in conflict with other pieces of statute, has been behind. And as a consequence, we've been behind all session. But we have a lot of different legislation to talk about this morning that has been taken up in the Labor Committee, and Tawny and I will go through them. We'll sort of tag team off on this. What we'd like to do is have your questions on the different legislation held towards the end of each section of our presentation. You can put them in the chat function if you like to make sure that we go back to them. We will make sure we have time in each segment to address questions. And if you don't, you can always contact either Tawny or myself. This presentation is also being recorded so you can view it again if you are really a glutton for punishment. So with that, we'll get started. So Tawny, you want to take it away and I'll jump in?
Yes, absolutely. So we're going to start with newly enacted laws. So much of the presentation today, we're focusing in on pending legislation, stuff that has not gone all the way through the legislative process, but we do have two pieces of legislation that people should have at top of mind that has already been passed. One of them, the first one, is the expansion of Maine's severance pay law. For those of you who are larger entities, you may often hear the severance pay law is referred to as Maine's Mini Warn Act. So this is the statute that requires notice and payment if there's going to be a plant closing or a shutdown of a division. The expansion of the law was approved by the governor on May 8th, and it'll be effective the 91st day after the session adjourns. So right now that's estimated to be end of August. What it does from an expansion standpoint is it removes the language of industrial, commercial facility in the language as to who the Maine Mini Warn Act applies to. So previously it indicated that it only applied to industrial or commercial facilities. Industrial or commercial has now been removed. So a covered establishment that closes or relocates doesn't have to be limited to industrial or commercial industries. As it applies to how does this affect industry moving forward, I think it's going to be extremely limited because commercial was so broad anyways, and the Maine Department of Labor viewed anything that could be a closing or relocation, which fit within the definition itself, as requiring that notice and potential severance depending on the time frame in which the individual had been employed. I don't see this currently as creating that much more work for entities that unfortunately have a closing or relocation. I will say that the chamber did an excellent job. The way that this bill was initially drafted would have been extremely problematic for employers. In part, it excluded this 3-year window. So in normal situations under the Mini Warn Act, if an individual has been employed for 3 years or fewer, they're not part of the severance payment that's required. That language was in there. Thankfully, amendments removed it so that we are dealing only with a change in that industrial or commercial language as it related to the closing or relocation of a covered establishment. Peter, anything to add on as to the severance pay?
Yeah, I'll just add this. In my conversations with Commissioner Laura Portman at DOL before the public hearing, it was clear to me that what they were seeking to do was to get to larger nonprofit agencies, specifically those involved in the healthcare industry, that they didn't think met the definition of an industrial facility. So if you are a nonprofit and you have more than 100 employees on this call today, you probably weren't you probably didn't fall under the severance pay law prior to the passage of this bill, but at the end of this year, you will.
The second bill, the second bill that's been enacted revises the Maine Human Rights Law. It's LD 707. It was approved by the governor on April 24th, and it'll have an effective date of June 29th. This changes the statutory language, but it doesn't substantively change any of the requirements that employers have. Instead, it deletes gender identity or expression from the definition of sexual orientation. That does not mean that gender identity or expression is not protected. Instead, recall that in past legislative sessions, gender identity and expression had become its own protected classification. So now what they've done is they've clarified that gender identity is not part of sexual orientation. It's its own subclass within the Maine Human Rights Act. So it doesn't substantively provide any change, but you may want to take a look at your EEO policy to make sure that you don't have gender identity or expression as a subset within sexual orientation anymore. If you were following parallel to the language of the Maine Human Rights Act. Peter, anything to add on that one?
Nope, you hit the nail on it.
So now we'll move on to the stuff that is pending, hasn't been enacted, and I'll turn it over to you, Peter, to start, and then I'll pipe in with my thoughts on things.
The first bill, 767, was a bill submitted by the Department of Labor to come up with a common definition of what constitutes retaliation. In Title 26 and the WPA, the Workplace Protection Act, which is Chapter 7, there are a variety of different definitions of what constitutes retaliation by an employer against an employee. The purpose of this bill was just to have a single definition. And the good news is that the department, and the bill did pass, so it did come out of committee, ought to pass. The good news is that the department testified that there's very little evidence of retaliation in the workplace by employers. And by very little, I mean like maybe 10 in an entire 12-month period, 10 different, instances. So I don't see this as a big deal. I think it will in some ways make it easier for employers to understand, and certainly their attorneys, in terms of a single definition of retaliation. 741 is actually up for work session this week. It would prohibit an employer from requiring an employee to repay them for any retraining they took while employed at the business and then left. There was a lot of testimony on this, and actually a lot of pushback from members of the committee against folks like myself who were opposed to this bill, that they didn't see the need to have the employer be reimbursed for this. However, there was also testimony that said, look, we've had an instance where we hired somebody they had worked for us and they asked for higher education. And so we paid for a college class for them. And before the class had even begun and we'd already paid the bill, they left. And now are we not entitled to request that money back? In most instances, employers don't ask for their training dollars back. However, in highly technically skilled areas where employers are paying for, intensive training around, machinists or IT or whatever, there's an expectation the employee is going to hang around and work there for a while. I'm not sure what the committee is going to do on this bill. There aren't a lot of instances, as I indicated, that employees are required to repay the employer. But nonetheless, they may focus on mandatory training. So if an employer mandates that an employee go to this training, they can't require the employee to pay them back. Our message to them was, if you don't allow employers to recoup legitimate, training costs when someone leaves, they're just not going to offer it. That doesn't serve anybody well. 1756 is also up on Thursday. And Tawny, I may let you talk a little bit more about this one. This is a very significant piece of legislation. It's what's known as captive audience legislation. It is only passed in Connecticut and Oregon. And the Connecticut Business and Industry Association is currently suing the state of Connecticut, alleging that the legislation or the law is unconstitutional. At its very heart, it's an attempt to limit an employer's ability to fight back against an organizing effort in their place of business. The NLRA imparts certain rights and protections on both individuals and businesses in a collective bargaining situation or an organizing situation. And employers have the right to require employees to go to meetings and pay them. They can't coerce or intimidate them into not joining a union, but they can explain why it might be problematic. At the same time, workers are entitled to try and organize on the employer's place of business. This would say that an employer cannot compel an employee to go to a meeting through retaliation. In other words, if they don't go, they either get fired, they get demoted, they lose hours, et cetera, et cetera. But unfortunately, the bill as written goes a lot deeper because it talks about political and religious speech in the workplace. And as you all know, in today's workplace, what's political and what is religious is in the eye of the beholder. And for instance, what could be impacted by this, and Connecticut has found out, is people have refused to go to a DEI training, for example. I don't have to go to that. I consider that political. It's likely to be unconstitutional, and if it passed here, and I'm sincerely hoping it doesn't, it's likely to be litigated. Tawny, I'll let you take over for a minute.
Yeah, I mean, so just as Peter said, one of the biggest problems with this is the definition of what political matters includes. So political matters isn't just matters relating to election for a political office or political parties, but also is going to include proposals to change public policy, and then civic, community, fraternal, or labor organizations. So civic and community aspects, I mean, anything concerning things that are going on socially with the country in and of itself likely will fall within this political matters definition, which then creates the concerns as to implicit bias training, diversity training, anything you may be doing to further DEI efforts, in a lot of ways is viewed as some form of political speech and therefore could become problematic. So as it relates to political matters, what happens is that employers then cannot discharge, discipline, or penalize or threaten to penalize an individual if they refuse to attend or participate in a meeting or training or any form of communication that relates to political matters. Now, this, unlike so many of the bills that we see, I think in Augusta, this one has teeth. So this one has the ability to bring a civil action. So if an employee believes that they've been forced to attend a meeting in which what they view is a political statement concerning community or a labor organization, then what we end up seeing is they have 90 days, they can file a civil action, they can, if they've experienced any adverse action, they could get back pay, they could get benefits, seniorities provided, and attorney's fees are also available for the individual. So if the individual gets counsel, sues the employer for violation of the statute, they would be entitled to attorney's fees as well. There's no requirement to go through the Maine Human Rights Commission, anything along those lines. They'd immediately be able to go to court. And because of how broad political matters is, any discussion that employers attempted to have if the organization was experiencing a union drive or other attempted to unionize the workforce, the employer would be limited at sharing their message concerning why they believe unionization is not appropriate at the workforce. They could still hold it, but they couldn't require anyone to attend the meeting itself. That is, you know, a snapshot of the current language. There does include an exemption if an individual is a religious employer, so a church or convention or association of churches, but that's the only exemption from the language itself. Peter?
Yeah, I mean, as you can see, it's quite a disconcerting piece of legislation. Unfortunately, I do think it's going to come out of the Labor Committee, ought to pass. I don't know if there'll be an amendment or not. And I actually think that if it comes out of committee, it's highly likely to pass in the House and the Senate and land on Governor Mills' desk. The administration did not testify on this bill, but the Attorney General did. And although he said that the bill, you know, it did face problems in Connecticut, he felt it was, quote, defensible here. So he testified in support of the bill. The next bill is LB 1496 to prohibit non-compete clauses. Back in the 129th legislature, the legislation was passed, the law was passed that did prohibit non-compete clauses. However, they were limited in the sense that if an employee made less than 400% of the poverty level, an employer could not compel an employee to sign a non-compete clause either as a condition of employment or after employment. This bill goes beyond that, and it strikes. It would basically eliminate the use of non-competes in Maine in general, but it specifically cites 3 different protections that employers were given or retained in 2019. And that's to protect an employer's trade secrets, to protect an employer's confidential information, or to ensure the employer's goodwill. So under this bill, absent the non-compete agreement, a individual business could build their business, build their client list, have trade secrets, and under this bill, an employee could work for that employer, walk out the door with their client list and trade secrets, and literally set up a business across the street to compete. We strongly oppose this. There was additional testimony. There wasn't a lot of testimony in support. There was significant testimony in opposition. The bill has not been scheduled for a work session in the committee yet. But I'm just going to tell you, I'm going to say the same thing about all of these bills. I remain very concerned about their disposition in the Labor Committee and the likelihood that they will come out to pass. So that's where that bill stands. Tawny, you want to add anything?
Yeah, for anyone who's been following the FTC proposed rule concerning non-compete agreements, I would shift your attention right now to this bill, because this is going to become just as problematic for Maine employers as the FTC rule is for the nation. But what it's going to do is put us at a higher disadvantage more generally. There are only a handful of exemptions, selling a business, or if you're a shareholder of an LLC, where potentially a non-compete would be permissible. But all your C-suite employees, they could all, walk away and begin competing the next day from your organization. Additionally, for those of you who are thinking to yourself, no problem, because we have operations in Massachusetts, or we have operations in, insert state of choice. This bill also has language that indicates that if you are an employee who's working in Maine, or an employer, you cannot use another state's law, even if you may be connected with that state. It'll be unenforceable. You can only use Maine law for an employee or an employer that's in Maine. Additionally, that's also, I think, going to adversely affect remote employees who are potentially working in Maine for entities kind of outside of the state as well. There is a proposed posting requirement, but really the concern is just the ability to protect information moving forward, especially as to your most senior team members and their ability to begin competing, right after they leave your organization. Peter?
The next bill is a bill that got a lot of attention early on in the session, an act to protect employers from workers from employer surveillance. I'm not going to spend a lot of time on how the bill looked as it was originally drafted, but in a nutshell, it pretty much would have ended any kind of employer oversight of employees. And you can look at that any way. It could be, recording of customer service calls. It could be observation. It could be software monitoring, keystroke monitoring, cameras in the workplace, etc. And there was zero proponent testimony of the bill except for the sponsor, who's the House chair of the Labor Committee. Zero. And yet they're still intent on going forward. There is an amended version of the bill, and I really want to focus on what the amended version of the bill looks like. It changes the definition of employer surveillance, so it doesn't include surveillance cameras for security or safety purposes, or GPS. For the same reason. It does include all other versions of surveillance. It says an employer can't use its employer surveillance unless the employer informs the employee before they begin the surveillance. It prohibits an employer from using any kind of audiovisual monitoring in an employee's residence, on their personal vehicle, or on the employee's property. It says that the employee can deny a request by an employer to install any kind of software monitoring on the employee's personal electronic devices for the purposes of employer surveillance. It requires an employer notify a prospective employee, so an applicant, during the interview process that the employer engages in employer surveillance. And then it adds a number of rulemaking functions for the Department of Labor. This has not in any way changed our opposition to the bill. The fact of the matter is, with employers more and more frequently granting remote work requests, and again, there are bills in to require employers to consider more remote work requests. At the same time, this bill says we want you to be able to work more from home, but we don't want the employer to monitor your progress at work. And as a consequence, that it's just going to translate into fewer opportunities to work from home. If an employer can't ensure productivity of their workers, then they're not going to allow them to leave the workspace or the traditional workspace. In addition, I know people looked at the personal device portion of listened to the amendment and said, well, that shouldn't be a big deal. But how many of you have software installed on your personal phone so you don't have to have two phones? I know I do. And the same may hold true to your personal laptop, for example. I want to use my laptop, so I'll let the employer. In this situation, an employee could say, I don't want to do that. I don't know what the options are at that point. This is a bill and is a solution in search of a problem. There are a number of these bills this session. It has come out, ought to pass, and it was divided along party lines. It will be going to the legislature for their full consideration in the next couple of weeks. Tawny?
Yeah, one of the big things is here, security or safety is broad, but it's still not going to permit for employers who may track when an employee logs onto their computer to determine what day they started working or what time they started working, what time they're supposed to check in. That would be outside of the scope. That would not be permissible. Employers specifically in construction, which may have remote kind of construction, direct care providers in healthcare who have some form of a tracking software on cell phones so that people can log in as to the time they get to one site versus the time they get to another site. That would all be impermissible. The security and safety becomes interesting because for retail establishments and for other secure locations, the financial industry, in most situations, our argument would be that cameras and other monitoring devices as to which accounts did a teller or somebody in the organization access and why could be argued that it's a security measure. However, we get a lot more data than just what was accessed that is outside of the security realm that also is going towards productivity. So anyone who is, I don't want to say using surveillance, but is otherwise tracking productivity of employees using any form of electronic data, that likely would not be permissible under the current amendments still concerning surveillance. So in so much as you're using collection of data for determining either profitability or productivity, that's concerning. And I think there's also just a general lack of understanding as to how much data is available pursuant to some of the programs that we all use very regularly, Outlook, Microsoft, they all show how often we're typing, how many times we're being interrupted by phone calls, like depending on what type of system you have, it could be that you cannot now use 75% of the functions that are in these programs that you're paying a lot of money for. So those are my thoughts on the surveillance bill. I agree it's very problematic, and if it is passed, will result in some significant changes that employers are going to need to make as to how they both measure productivity, safety, and security. Peter, you want to jump to the caregiver expansion?
Yeah. One more thing on surveillance. I worry about the notice portion, particularly to applicants. What does that? How does somebody prove they received notice? There have to be in writing. There's not an employer-employee relationship there to start with. I think it's a trap for the unwary small business person. Very quickly on 999, this is a bill that would add to the definition of family member grandparents to Maine's existing FMLA law, not necessarily the paid family medical leave law that we're discussing in the State House, but the existing state law. That's what this bill will do. It was a unanimous law to pass. 1376, again, very quickly. This bill will increase Maine's hourly minimum wage. It was originally to $15 an hour in January, and then $1 a year through 2033 till we got to $24 an hour, plus the annual indexing, which would have given us a minimum wage of probably at least $30 an hour by 2033. Instead, the committee has decided to just increase the minimum wage to $15 an hour, effective 1/1/24, in addition to the indexing that will take place in October of this year. There was really no reason for them to do this except they could. The minimum wage question had really been addressed by the referendum in 2016. Certainly that's what proponents said. And, again, a minimum wage of $15 an hour may be, eminently payable in the greater Portland, York County, Cumberland County areas. But in Franklin County, Washington County, Aroostook County, even Penobscot County, it's a much more difficult requirement for small employers. It passed out of the committee along party lines, the Democrats in opposition, in support, Republicans in opposition. It will now go to the full legislature. I could not tell you what will happen when it reaches the full legislature. I do understand that the governor is not particularly supportive of this idea. Tawny, you want to talk Maine Human Rights Act?
Yes, absolutely. So currently pending LD 1423, an act to increase the limits on awards for compensatory and punitive damages. What this would do is it doubles the caps that are currently set in the Maine Human Rights Act. So if you have between 15 and 100 employees, you have a $50,000 cap on any punitive and compensatory damages that could be awarded if you were successfully sued for discrimination. This would double it to 100,000. So you take whatever your cap is right now. So 101 to 200 employees, the current cap is 100,000. This would triple it to 300,000. For employers that have more than 200 but less than 500, it would move it from 300,000 to 500,000. And for employers with 500 employees or more, it would move the cap from 500,000 to $1 million. This is a massive jump. It is not good for employers if they were ever to get to trial or jury determination, but not just that, it also becomes difficult as we settle matters. If you've ever been part of one of these lawsuits, you understand that oftentimes we do recommend settling based off of, a number of different factors. This is going to increase settlement value of claims that you may see in the future, and just is not great for employers who may be experiencing specifically claims that are, non-meritorious. Next, LD 1501, an act to protect Maine citizens from discrimination by including vaccination status as a protected class. I'm actually going to talk about this one at the same time we talk about LD 1663, which is to add political affiliation as a protected class. 1501 and 1663 seek to add vaccination status and political affiliation. And it's not just in the employer portion of this statute, but in all aspects of the Maine Human Rights Statute. As to vaccination status, it is whether or not a person's received any particular vaccine. It's not just COVID-19, but any vaccination. And then for political affiliation, it is a very broad definition concerning belonging or endorsing not just a party, but a political philosophy, creed, or ideal. And the broadness of that becomes very concerning, as we've talked about in the past. Many of the social issues that we see currently across the United States landscape have been politicized. And therefore, an argument could be made that if somebody's view is contrary to your diversity initiatives or otherwise is adversely affecting the rights of other employees, but they're indicating that it's based off of a political philosophy, creed, or ideal, that they would be within a protected classification. So that's a vaccination and political affiliation proposed amendments. Peter, anything on as to the ones that I've discussed so far?
Yeah, I don't think either bill is going anywhere. I think there'll be a divided report in the Judiciary Committee on both of those bills, where the majority ought not to pass, probably for both. So I don't think either will be put into the Maine Human Rights Act.
967, strengthen protections of persons after there's been no reasonable grounds to believe unlawful discrimination occurred. This is helpful to employers. You're not going to hear us, Peter and I, say that, I think, very often during the course of today's presentation. But what this does is it provides that if there's been a finding of no reasonable grounds to believe that discrimination occurred, it limits the commission's ability and the commission staff's ability to then help an employee to file a lawsuit against the employer. So you'll recall, an individual can go through the Maine human rights process, go all the way through, get a finding of no reasonable cause, but then could still sue you as an employer. What this bill does is it says, yes, the employee can do that, but they can't receive help, time, anything along those lines from the Maine Human Rights Commission to assist in that process. It also includes language that if the Maine Human Rights Commission were to assist or to file a file a lawsuit on behalf of that employee, that defendants' reasonable attorney's fees and costs could be sought in that situation. Additionally, 1001, an act to amend regarding right to sue letters. This provides that after 180 days, an employee or an employee's counsel can request what's known as a right to sue letter, which checks the box to say, hey, we've used the administrative process as the statute stands. Again, I think it might be we got two bills that are helpful for us. What this does is it requires that an employee cannot file a lawsuit before they get the right to sue letter. What a lot of employment lawyers are seeing recently from the defense side is either plaintiff or plaintiff's counsel is filing a lawsuit in state or federal court, but they have not yet received the right to sue letter. And in those situations, we present a defense saying that their damages are limited. What we've seen is many employees going and getting the right to sue letter in a tardy fashion and then kind of checking that box and the court permitting them to proceed. This statute would say you can't proceed unless you have the right to sue letter prior to filing the civil action. So it clarifies what I believe the intention was, but which has been lost in recent court rulings.
So, Tawny, very quickly on both of those bills, 967 has already been killed in the House, unfortunately. However, 1001 was actually the Maine State Chamber's HR Policy Committee's bill that they asked to have submitted and that I worked on. I did get a 10-3 ought to pass report out of the committee on that, with both the House and the Senate chairs supporting the position. The one thing that we had added that they took out was the ability, and this is language modeled after the provisions the EEOC has, to have the Maine Human Rights Commission not need to pursue after a certain period of time non-meritorious cases, and they would not give the commission that authority. So that part was taken out. The rest of the bills going forward, I anticipate it will be up in the House of the Senate this week. So we're back on wage and hour here, and we're gonna, in order to give us some time to do the paid family medical leave legislation, we'll try and do this quickly. 827, as I indicated, was a bill that was put in by the House Chair of the Labor Committee. Again, no proponents other than her. That essentially, and just to break it down, it sets up a request. And it sets up in statute what's currently happening organically in the workplace. It will require an employee to have a formal answer in writing to an employer, to have a formal answer in writing to an employee who requests a flexible work schedule. And a flexible work schedule is defined as up to 6 months in length. They don't have to grant it, and they apparently don't have to say why they don't grant it. They can't retaliate against the employee for asking for the flexible work schedule. And with certain notice, the employer would have the right to recall that employee from the flexible work schedule if their workload at the business required or permitted it. It's not that this is a terrible bill, it's just that it's an unnecessary bill. I mean, terrible within the standards of all the terrible bills that are there. And it interferes with the employer-employee relationship, and the state should not be dictating specific employment practices in the workplace. I don't know how this bill will proceed. It's divided right now along party lines. It will come out of the Labor Committee after a language review. What happens to it in the full in the full legislature, I can't tell you. And you'll see that 961 is a companion bill. Same thing, a little bit more detailed. The committee decided to kill that one. 1190 is the what's known as restrictive scheduling bill. Only one other state has it. And it's an expansive bill. Again, not going to spend a lot of time on it. Suffice it to say that it would require an employer to give up to 2 weeks notice of a schedule, and then any changes that took place at the employer's request because someone called out and you needed to be called in. There's a series of notice tied to bonus pay on when you were notified. So you could require an employee could end up paying the equivalent of 16 hours for an 8-hour shift under this bill. And there's all kinds of private rights of action for violations, et cetera, in the law. It had a public hearing, significant opposition, very little support, and then it has not been scheduled for a work session.
There's also really concerning rebuttable presumption language in this bill that says if within 90 days of the exercise of any of these rights, whether it's refusal to work a shift or complaining about a schedule change, there's a rebuttable presumption that the employer took the adverse action in retaliation for exercise of those rights. So a really concerning provision there as well.
1278 is a Department of Labor bill. That actually came out unanimous, ought to pass. It deals with members of the employer's family and salaried employees. It exempts them from the requirement that the employer pay at a regular interval in full. It removes the exemption for salaried employees from the requirements related to the rate of pay and record keeping. And it adds S Corps and LLCs to the exemptions from requirements relating to the rate of pay and records of timed work. So it's more of a technical aspect than anything else, and it was unanimous ought to pass. 513 is one of the more significant bills of the session. You may remember this. We dealt with this in the last 3 previous legislative sessions. It's the bill that changes the monetary threshold as part of the 3-prong test that divides salaried employees from hourly employees. In Maine, we tie that to a multiplier to the minimum wage. It's 3,000 times the minimum wage. This bill seeks to manipulate that multiplier and increase it over the next 3 years from 3,500 times, 4,000 times, and 4,500 times the state's minimum wage, which would bring us to if you don't figure in changes to adjustments to the CPI and the minimum wage, about $68,000 as the monetary threshold by 2026. And if you figure in some form of CPI adjustment, it's north of 70,000. We would have the highest salary threshold in the country. Again, they had a public hearing on this, not a lot of support, a lot of opposition, and they have not brought it back for a work session yet. Tawny, do you want to add anything to that?
I mean, it's problematic. I mean, that's really what it comes down to is that, you know, we're going to see if this continues, we're going to see the salary push up again in the same way that we did. So those are, you know, it's problematic, I guess, is the best way to say it. And similarly, recall that we still are permitting different states and different cities and municipalities to have their own statutes. And what I would expect we would see is an even higher kind of rate increase in those municipalities that already are above what the state standard is.
1703 is actually being heard this afternoon in the Labor Committee. It does exactly what it says. It creates what's known as the Maine Equal Pay Law, which prohibits discrimination and differentiations in pay based on somebody's race. I feel like this is already taken care of in the Maine Human Rights Act around discrimination. It's not a bill that I anticipate a lot of people are going to wade into for a variety of different reasons. I do think the objective is to get a statement regarding race and pay, equal pay, into Maine statute, not unlike gender was back in 2019. This bill will definitely pass. And then the last bill is 936, disclosure of pay ranges and record keeping. That bill would require an employer. It had a lot of record keeping requirements. They've gotten rid of those because the department said, look, we already have requirements for keeping the people's pay records and pay ranges in law already. But it does require the employer to, when there's an advertisement for a position, that they would have to post notice of what the salary range is in any kind of advertisements. We questioned them on whether that meant like a help wanted sign or now hiring. And the committee says, no, we don't mean that. We mean like if you advertise in the paper or you advertise, you know, through the internet or something that you have to disclose, we're going to pay you between X and Y. And the reason is we want to eliminate opportunity for gender pay discrimination. Some of this gets back to a court case involving a Northern Maine employer. At any rate, this bill is going to pass as well, even though we opposed it pretty vigorously as being unnecessary and administratively burdensome. I know, Tawny, that Connecticut has this, so does New York. You want to talk a little bit about the impact of it?
Yeah, no, so this is, if you are currently hiring or you have employees in other states, you likely have already begun the process of disclosure of pay ranges. One of the issues here is that you need to list the range of pay that the employer will offer to a successful applicant, which means oftentimes we see somebody who has more skill set or better credentials than we were expecting them to have, and we would be willing to pay them more. But if we were to list, hey, this position pays between $30 and $32 an hour, right? And then we get somebody who we would arguably pay $36 for, that would be outside the pay range and could be problematic. So what we think we're going to see a lot of employers doing, which doesn't meet, I think, what the legislature is trying to do, but would be permissible, is simply saying something to the extent of pay range is $30 plus or something along those lines. But it is going to be a lot more work for employers, and you're going to need to be mindful because current employees are also going to be provided with the ability to ask, what's the current range of pay within my position itself? So if you're trying to keep pay rate or ranges kind of more confidential, you're likely going to be unable to continue to do so under this statute. Workers' compensation. We'll run through this fairly quickly just based off of time, but an act to ensure accountability for workplace sexual harassment. This provides the individual could have individualized tort liability if they sexually harass or sexually assault a coworker. There's indication that the employer is not going to be held liable for a tort cause of action, but really what this comes down to is if you have EPLI insurance, it's going to likely increase the costs associated with insurance because your EPLI or your directors and officers insurance likely would cover for these actions. So while there's an attempt to provide individualized liability for a bad actor, in most cases, those bad actors are going to be judgment proof. So they're not going to be able to get at them, or the employer's insurance is going to cover. So honestly, I think what this does, unfortunately, is just increases costs surrounding EPLI insurance or other general insurance premiums. Peter?
This is a very troubling bill. It's the first bill that Maine has had that potentially adds an exception to exclusive remedy. The other bill on this list is 1385, but that was killed unanimously in committee just late last week. But LD 53 has passed both the House and the Senate, and it will go to the governor. As it's amended, as Tawny indicated, it makes an employee, a supervisor, an officer, or director individually liable for sexual harassment or sexual assault, or an intentional tort related to sexual harassment or sexual assault. And that is going to encourage people to bring litigation in these cases. And if a small business person is the officer or director, then the business ends up caught up in this. It's very problematic. We've vigorously opposed it, and we will be asking the governor for a veto on this bill. To just save some time, Tawny, let's just jump down to 1896, which will be worked on, I believe it's either this afternoon or Thursday afternoon. And that is a bill that would index workers' compensation benefits annually to the CPI. And that's not just all benefits. That's just not benefits on total incapacity, in which, as a result of the 2019 legislation, COLAs were added, but to all benefits every year. COLAs were one of the leading causes of Maine's high cost system prior to the 92 reforms. They were removed in their entirety as a result of the 92 reforms. And in 2019, we did negotiate with folks when we were dealing with about 35 different comp bills to reinstate cost of living adjustments to people who fall under Section 212 of the comp law. And that's someone who is an individual that has total incapacity. They are totally, they are without the ability to work and will be for all the foreseeable future. And after 5 years, if they've been fallen under Section 212 of the law, they are entitled to a COLA attached to changes in the state's average weekly wage. Those are the only individuals in Maine's workers' compensation that are eligible. This would apply them to all injuries, all injured workers, and it appears that it would be retroactive to all dates of injury, which means there would be a significant unfunded liability associated with this. We have strongly opposed the bill. I have spoken with the governor's office on this. They are not in support of this piece of legislation. And yet I still feel that it's going to come out of the Labor Committee with an affirmative ought to pass vote. We'll see. Tawny, you want to add anything?
No, we'll move on to unemployment. So we went back and forth as to whether LD 1332 should be here on unemployment or if it should be in wage and hour and minimum wage. What this does is proposes to change the minimum wage for employees who are 14 or 15 years old to $7.75 an hour, and to individuals who are 16 or 17 years old to $8.50 an hour, and then amend unemployment requirements that they would have to partake in registering for work. Anything else on that one, Peter?
Nope.
Fairness in unemployment benefits by clarifying laws regarding union organization, LD 1368. This one would provide that as opposed to actively applying for different positions in organization, instead a union member is defined as actively seeking work if they maintain contact with the union and complies with any placement services the union hiring hall has in seeking work. So instead of doing applications through non-unionized employers, instead, as long as the employee is connected with the union hiring hall, that would be sufficient to meet the definition of actively seeking work, unfortunately. So this one is not a great bill because it would then say, hey, as a union member, I'm not going to work in any non-unionized location. I'm only going to seek work through the union. And then an actor, oh yeah, go Peter.
That's important. The chamber did oppose this bill. Individual employers, particularly in the construction world, have come in and asked for a similar exemption. And the problem is, for the first 6 weeks that someone receives benefits, whether they're in a union or a non-union shop, if they're not compelled to look for work like the rest of everybody else, then essentially the entire system is being the entire system is subsidizing that set of workers. You have a parallel system of unemployment insurance, and it's not fair. And we've opposed it. I am almost certain this will also pass in the committee.
LD 1464. This one's also concerning. It does exactly what it says. It removes a 7-day waiting period. For employers who have work weeks that fluctuate or change, that means that an employee who has less hours in week 2 than they did in week 1 may be entitled to some form of unemployment based off of that decrease in hours. So it would be problematic from that standpoint, especially for fluctuating work week employers. Some industry specific LDs. Do you want to jump in on those ones, Peter?
No, I'd rather jump to paid family medical leave. I think.
Okay, the only one that I do want to draw people's attention to, the hospitality one, what this would do is it would make Maine's law parallel to what the federal standard is, which will be helpful for hospitality employers. And then if you have time, take a look at LD 1794, even if you're not in pulp and paper. And the reason is because this could be a preview of what will be attempted in industry, kind of more generally limiting required and mandatory overtime at different levels. And this is a per day overtime discussion, not simply a per week overtime. We also have a number of concept drafts you can check out online, kind of those LDs, but we are unlikely to see anything happen with those in the next month or two, correct, Peter?
Yeah, I mean, I think it's more likely that the bills you see on this slide will end up being carried over because they are concept drafts. And some of them are very big pieces of legislation, including 324, which is, and the ending of employment at will. And that's not a discussion you have in the last 3 or 4 weeks of the session.
Okay, we don't have any pending questions on past and pending legislation. So Peter, I think we take our last half hour and move on to proposed paid family. Oh, Yes, the presentation will be made available to everyone. Proposed Paid Family and Medical Leave Act, Peter.
As some of you know, the issue of the establishment of a paid family medical leave program in Maine has been a part of conversations for the last few legislative sessions. And a commission was formed 2 years ago to look at what a paid family medical leave program might look like, and given the authority and money to hire an actuary to make sure that they had real numbers to look at. At the same time, the Maine People's Alliance, a Southern Maine area advocacy group, began the collection of signatures to put on the ballot their own vision of paid family medical leave. They did successfully gather signatures, and at the same time, the commission finished its work in December and released a report in January that laid out their vision of what a paid family medical leave program in Maine would look like. However, that's as far as things went. A bill was printed 738 that was a concept draft and a placeholder, but at the same time, the sponsor of the bill and the co-chairs of the commission began a road trip around the state, and some of you have seen their presentation outlining what the commission's recommendations are, and then, you know, what people might be looking at in terms of what changes would you make, you know, what works for you, what doesn't work for you. All the while, I think with a very set, clear idea of what they are looking for in a paid FMLA program. And last week, late, LR9 was released, which is known as a sponsor amendment to, it was going to be 738. Now there's going to be a separate bill. My understanding is the bill has roughly 100 co-sponsors to it. And should be referenced either today, it should be today, if not Thursday. And the plan is to have a public hearing on the bill May the 25th, so a week from this Thursday. It is a very significant program. It is a very significant public policy issue. We have had conversations. I have been part of a group of stakeholders representing various business associations that have met with the sponsors as well as the governor and the governor's staff, a couple of commissioners on the program and the concerns the business community has. Nonetheless, we wanted to go through with you a little bit about what paid family medical leave under LR9 would look like. The one thing I can tell you is that it is not paid family medical leave. What it is the creation of a long-term disability insurance program, or a short-term, however you want to look at it, of up to 12 weeks of paid leave, to a very expanded definition of family members, and accompanied by a funding mechanism that imposes a 1% payroll tax on employers and employees in the state of Maine. The idea is they will collect benefits for roughly 16 months, take the temperature of the fund, and then potentially begin paying out benefits after that time. So, Tawny, do you want to go through some of these things? You want us to do it together?
Yeah, no, I'll start and we'll kind of jump back and forth as we have. So what we've done here, we have a handful of slides, and really we're highlighting, I think, some of the main points within the bill itself so that you understand where we're at. And also I'll be using language for anyone who is currently aware of or has employees in Massachusetts, how it compares with some of the language there, which they instituted a few years ago. Also, I think it's important to understand how this compares and contrasts to your current FMLA, unpaid, in most cases, unpaid FMLA that you're providing, or for employers who currently have a private short-term disability plan, ways in which this proposed act is going to be different from what you're already providing. And unfortunately, while there is a mechanism here where you could opt out of this program if you have a policy or a practice that is meeting or exceeding what this statute provides, I think it's going to be highly unlikely that a majority of individuals who have short-term disability policies are going to have ones in place that meet the standard that's set forth under the proposed act. What we're going to start with is the definition section, because as an attorney, I like to just start with the driest part, but at the same time, the dryness of the definition aspect really plays a role in how we're going to analyze the rest of the provisions. And the first is an application year, and that's defined as a 12-month period beginning on the first day of the calendar year, where an individual files an application for family leave benefits or medical leave benefits. I focus on this because if you've had your handbook or your FMLA policy reviewed by Employment Council, it's likely that they've recommended that your language should use what's called a rolling calendar year period, which means that the first date of any application year is the first date in which an individual takes either medical or family leave. That indicates the start of the 1-year period for determining eligibility for FMLA or Maine Family Medical Leave. This, however, provides that everyone in your organization has the same application year, which is January 1st of the calendar year. So the first day of the calendar year in which the application's filed. And this is going to be important as we talk about the amount of time that individuals are entitled to and the ability that employees, I believe, are going to have to stack leave. The next definition that's really important is family member, which is much more expansive than what is the current definition under federal and state law. So here it includes child, parent, spouse, grandparent, grandchild, sibling, and it also has this language. And when we say child, parent, spouse in loco parenti, similar language to what we see under federal and state law. But we also have this additional language that says that the covered individual can receive leave if the relationship includes a significant personal bond that is like a family relationship without regard to biological or legal relationship. This could be roommate, it could be close friend, it could be individual who, it's not even in loco parenti. It's not somebody who helped raise the individual because that's already been defined, but just somebody who has a significant personal bond. I mean, the good news is as an employer, you're not going to have to make the determination as to significant personal bond. The administrator of the act is going to need to, but instead, what we're going to see is a very expansive leave. I think that come Memorial Day, a lot of people are going to have significant personal relationships that are going to take them out of work for 12 weeks to care for someone who they have a personal bond with. Peter, anything concerning that definition section before we turn to eligibility?
Yeah, this is what's known as affinity relationships, and has been something that the sponsors of the bill have been very supportive of. We were not during the commission period. We are not now. We can come back to this at the end after we've run through it, but it's this kind of expansive definition that encourages absenteeism in the workplace, and there is nothing to address absenteeism in this bill for employers. So, and again, this is one of the primary reasons why this isn't family medical leave and why this is a long-term disability insurance policy. So, Tawny?
So an individual is eligible to take leave. So the covered individual can take it for birth, care, adoption of a newborn, or placement. It doesn't have to be a newborn for adoption or foster care. Care of family members for the qualifying exigency. So qualifying exigency, family member, service member, we see all of those in the Maine FMLA unpaid. And we also have this catch-all in eligibility section F that really restates everything that you're currently allowed under the Maine unpaid family medical leave. You'll see the addition here of safe leave, and safe leave is leave that's taken because the individual or the individual's family member is a victim of violence, assault, or sexual assault, stalking, or any act that would support an order of protection. So an order of protection now would provide availability for this leave. It could be somebody who's simply seeking an order of protection. So if someone's parent, child is seeking an order of protection, that would entitle them to leave. Obtaining medical care or mental health counseling as a result of this. Anything concerning safety as to securing a home or location from acts of violence, and seeking legal assistance. So the safe leave is very expansive, and unfortunately something where significant data is likely going to need to be provided to the administrator. Why this becomes more difficult, though, is safe leave is something that isn't planned for in the vast majority of situations, is not something that's planned for. For any employer who's dealt with domestic violence leave already, you know that we're required to provide it under Maine law. This, however, is going to provide it in a paid format, and it's going to provide that up to 12 weeks, so significantly longer. Additionally, eligibility as it relates to the child's birth or the first 12 months of placement. This is one of the important elements as to why I included application year in the definitions. So let's say that an individual gives birth at the beginning of October. So the first week of October, an individual gives birth. They're then provided with 12 weeks of leave, okay, in that calendar year. So if you give birth in October of 2030, you take off October, November, December, your 12 weeks. You then get to a new application year, but the child is still less than 12 months old. Based off of the way that the bill's currently written, I believe the employee on January 1st could reapply for, could make another application and be entitled to another 12 weeks of leave, and take off January, February, and March to care for that child who's less than 12 months old, and it's a new application year. So that becomes problematic. One of the questions that we just received was who would determine whether or not there was a significant personal bond if the employer utilized a private option. It's a really good question. Depending on how your short-term disability policy is set up, it could be whoever the provider is who is acting in that capacity. But if you yourself are determining eligibility for short-term disability, or you have an administrator, it would be the administrator of your short-term disability policy who would determine if there was a significant personal bond. We do expect, under the proposed language, there would be rules related to it. The hope would be that the rules regarding the program would provide additional guidance as to what a close personal bond would be.
There's another question, Tawny, regarding the administrative function of the oversight board and the ability to levy the tax, and would they have to go back to the legislature? And my answer to that is no. I don't think it's the intent. I think it's to be operated similar to the unemployment insurance tax levying, where the bureau, it levies the tax without legislative approval. that's the purpose of the fiduciary responsibility language in that section. I think it's so the taxes it's enough to pay the benefits, but it doesn't become bloated with too much money. Of course, that's a nice theory. I don't know what will really happen, but yeah, no, I don't think the idea is they have to go back to the legislature to get approval.
A question concerning whether or not an employee or a parent could take 12 weeks off, we get to May, 12 weeks of summer. If the child had a serious health condition and they were able to show that serious health condition, yes, there is a potential that every year that employee could take 12 weeks of leave, but the child would either have to be within its first 12 months of life, within its first 12 months of placement in that employee's home based off of adoption or foster care, or have a serious health condition, or otherwise fall within that safe leave. So potentially if you had a situation where there was an order of protection from one parent to another, then we could see safe leave also providing, unfortunately, some annual leave if they found themselves in that situation annually. But just like every parent taking off 12 weeks during summer and being paid by the fund, no, unless there's a serious health condition, based off of my current reading and understanding of the language.
So a couple for attendees real quickly. I did just drop the sponsor amendment into the chat box. It's a PDF. If you want to pull it down, then you can see it for yourself. But to Josh's question, if you look on page 6 in the center of the page, Tawny and I talked about this last night. I think it is possible that in the event of a birth of a child in particular, that you could take 12 weeks of medical leave associated with a birth, and then take another 12 weeks of bonding leave, provided it was, the exception is right there, supported by a documentation from a healthcare provider. So a doctor could say, yes, they need not only the 12 weeks of medical leave, but the bonding leave on top of that for a total of 24 weeks as an exception.
As to kind of the funding mechanism, contributions would begin being made on January 1st of 2025, and employees would begin to be able to start making claims on May 1st, 2026. And you're saying to yourself, okay, but how do we get to funding? So funding the fund, we're going to jump a little bit. So an employer is going to remit to fund premiums, and that's going to be done quarterly. And the premium amount can't be more than a combined rate of 1% of wages. Now, this is interesting because when we talk about who's an employer under the statute, it's everyone but the federal government. So there have been discussions previously about, will this only apply to certain employers, or will it apply to all employers? Right now, employer is defined as anyone but the federal government. But there are these exceptions for employers who have 15 or fewer employees. And for employers with 15 or with 14 or fewer employees, there is no exception, but the funding provides that if you have 15 or more employees, you can deduct up to 50% of the premium from the employee's wages. So if you have 15 or more employees, instead of paying the full 1%, instead you would pay 50%, and you could take 50% from the employee and then pay that quarterly. Peter, I feel like I've butchered that. Thoughts on the funding aspect?
So to make it simple, if you are an employer with more than 15 employees, you are going to be required to split the premium with your workers. So the 1% will come under the current draft of the bill. 50% of it will come out of your pocket, and 50% of it will come out of the employee's pocket. If you have 15 or fewer employees, the small business is not required to contribute to the premium. The employees would pay 50% of the premium. And that means the other half of that premium is probably subsidized across the rest, socialized across the rest of the employer base. And the language is kind of, it's not very straightforward. It's, 50%, 50%. Supporters of the bill have been consistent in their calling it a contribution and not a tax, but it is a payroll tax. So anyhow, that starts January the 1st of 2025 under the bill.
There's also language concerning benefits during that leave period that becomes concerning. The taking of family leave or medical leave cannot affect the right to accrue vacation time, sick time bonuses, seniority, length of service credits, or other programs. If you currently have a policy where employees only earn PTO or vacation for hours actually worked, that would not be permissible. And that would have to be amended under the Paid Family Medical Leave Act. And also, current language would appear to indicate that people need to continue to earn paid leave while they're on leave, even though they're not working. So figuring out how you're going to account for that earned paid leave, if it's 40 hours a week as they normally were working or another period. Anything to add as to that benefit piece, Peter?
No, but I do want to turn to a question that is in the chat box because it's important. It says, relative to the FMLA, if the employer has not worked a required 12 months and 1,250 hours, do they have job protections while taking paid leave? I would say two things here. First of all, under this proposal, the 12 months and 1,250 hours is not applicable. It's a different standard. Instead, the standard is a base period, and they have to have earnings in the first 4 calendar quarters immediately preceding the first day of an individual's benefit year. So there is no required number of work months that they've worked with the employer or the number of hours they've worked for an employer. Instead, it's based on an amorphous earnings over 4 quarters. But it doesn't say, there is no directive as to how much that is. So it's a much more fluid standard for eligibility under this law that would take place under this law. And as far as job protections go, that's a different issue, and it goes to a hardship provision that is in towards the end of the bill. And Tony, I don't want to jump ahead, but maybe we ought to talk about that for a minute.
Yeah, no, I actually did jump ahead in the slide so we could talk about it. I think it's important to get that in. So
yeah, you want to go ahead? Yeah.
So let's say you have someone join you and a week later they request this paid leave. It's like Peter said, there's not that 12 months, 1,250 hours. If the administrator of the fund determines they're entitled to the leave because of past work experience, they'd be entitled to it. The only way in which so then there's retaliation that's prohibited. You couldn't terminate them. You couldn't put someone else in the job. The job would have to remain open and available for them to return to. And this is all in section 850-J, prohibited practices. The only way you would be able to, and you'd have to fire the person. It's not just like, hey, we put someone else in the position. But an employer who has less than 15 employees isn't prohibited from retaliating against an individual if it would impose an undue hardship that results in, and this is interesting because they kind of go into detail about that undue hardship. that results in significant difficulty or expense to the employer when considered in relation to the size, financial resources, natures, or structures of the employer's business. So you have to take all of those elements into regard if the individual or the employer has 15 or fewer employees. But for any employer who has more than 15 employees, you are just out and out restricted from retaliation. So you can't discharge, fire, suspend, discipline, hold them accountable to attendance or application policies. All of that would be impermissible while they're on the protected paid FMLA leave. You also can't change status, employee benefits, seniority. So you wouldn't even be able to move them to another position. This is going to become specifically difficult for individuals who are seeking some type of intermittent leave during the course of their leave itself.
Yeah, and I just want to on the hardship provision, that an employer just doesn't get to decide this is going to be a hardship under the categories or exceptions that are found in the law. That is, size, financial resources, significant difficulty or expenses. There's an appeals process. There's a multi-level appeals process. So first you can appeal to the administrator over the employer's decision, and then you can appeal to the courts over the administrator's position and the employer's position, assuming. So there's no savings to the employer to all this, because this is litigation. It's no different from what happens at the unemployment insurance division when you are controverting a case regarding someone's eligibility. And it's no different in workers' comp that you could end up in superior court after appealing the appellate divisions. So it's expensive, and a small business person is going to get caught up on this. And remember, for those of you that are on this call, many of you are well versed in FMLA law in Maine, unpaid FMLA law in Maine. But this is going to apply to every employer in the state of Maine going forward. Our law traditionally has stopped at 15 or fewer employees, no more. This goes to 0. So small businesses who have never dealt with FMLA before are now going to have to deal with this.
We seem to have Breen, we have a raised hand.
Yeah, I was just wondering if you think that this will inadvertently basically lead to discrimination, because if you were hiring and someone appeared pregnant, why would someone be tempted not to hire that person basically just for that reason, or even just because they're older of the woman of childbearing age?
It's a good question. I lean towards no, that it's not going to increase it anymore. For someone who is pregnant, everyone in the state already had obligations under the Maine Human Rights Act, and to not discriminate against an individual on the basis of a disability, and pregnancy would fall within that definition. The sheer quantity of time, that 12 weeks, maybe it increases it. Maybe people have it on top of mind at the beginning of the discussion as to, gosh, this person could, join me, and a week later they're going to be out then for 12 weeks potentially. I mean, I know I started with it, and I'm not trying to be an alarmist, but potentially 24 weeks. That's, I think, where things become problematic, is if we go back in the slides, and I don't mean to give anyone whiplash, but this application year definition is extremely concerning, because it's going to allow the stacking of leave so that people are out for 24 weeks or more at a time.
Tawny, we are sort of at our time maximum, and I don't want to shut this off if you think there's something else we have to cover that we haven't in this yet.
Really, I would very much urge individuals to take a look at the proposed language that Peter shared in the comments section. Please don't hesitate to reach out to Peter or I if you have questions about where it currently stands and how it would interrelate with current FMLA, current Maine Family Medical Leave, short-term disability policies, the ADA, any of those things. But be mindful, I do think that it is unlikely that current STD policies are going to kind of meet the standard that is required under this policy.
Yeah, let me just make a few more remarks to that. I just put my email in the chat. If any of you have the time to take a look at the draft that I just sent you, the amendment, and you have thoughts or concerns, please email them to me, because the public hearing is next week, next Thursday. In addition, if you're really concerned about the impact on your company, consider coming and testifying on the bill. And if you need assistance with that, we'd be glad to help you. But this is probably one of the marquee issues of the legislative session. Layered over top of this is the looming Maine People's Alliance referendum question, and whether they decide to go forward with that or not is probably going to be based on what happens to this bill before the legislature goes home. I think the challenge for the business community in all this is we won't know how much this costs unless we can get this actuarially priced between now and the end of session. And quite frankly, I am working on trying to find a way to do that. But this is a significant policy issue that will have significant issue in the workplace. And honestly, proponents of the bill don't want to answer the question about absenteeism and how workplaces will continue to be managed, and businesses do whatever it is they do, make their widget, provide their product, hotels, restaurants. This does apply to seasonal workers and part-time workers as well. It's everybody in the state of Maine. So we have a lot of concerns with this. It's not going to go away, but there should be a better way to do this, one that's more workable for the business community. That's my 2 cents worth. Anything else from anyone else this morning? Mark, I'll hand it off to you.
You know where the governor stands on some of this?
The governor has expressed concerns on this, Orion. That's all I can tell you.
Okay, well, thank you very, very much, Peter and Tawny, for your time and your expertise. We deeply appreciate it. As both Peter and Tawny mentioned, the recording and the slide deck, including Peter's amendment document, will be available on our website later. I'd like to again go through our sponsors list to thank Verrill for being a premier sponsor. And our series sponsors are AARP, Central Maine Power, Delta Dental, Eaton Peabody, First Light, Kennebec Savings Bank, and Sun Life. Our supporting sponsor today was Procter & Gamble. And I would like to draw your attention quickly before we close out. We will be holding our 2023 Healthcare Forum on Thursday, June 1st. This will also be a virtual event from 9 to 10:30. And again, thank you all for participating, especially Tawny and Peter, and have a great day.